I'm Judge Michael Davis, and we're here today at First Appearance Court. To those of you who are in the jails, you're here today because you've been arrested, and under the laws of the state of Florida, you have the right to see a neutral judge within 24 hours of being arrested. Now, my job today is to decide two things. The first is whether or not there was probable cause, legal cause, to arrest you. And if I find that there was, I'm going to set a reasonable bond, also known as bail, in your case, if it's applicable under the law. Now, today is not your trial. You're going to be assigned to a division judge, and you're going to have the opportunity to see him or her. And at that point, and also you'll have the opportunity to talk to an attorney, and that will be the time to possibly talk about the facts of your case. Today, do not talk about the facts of your case. Everything that you're saying is being recorded both on video and on audio, and you have the right to remain silent. What we may talk about today are things like your community ties and your ability to post bond, which will help me in setting a reasonable bond for you. You also have the right to an attorney. The public defender's office is there with you in the main jail, and there's also a representative here with me in my courtroom. They'll represent you today free of charge at this hearing at least. Or you may hire a private attorney, and if you've done so and they're not here, let me know and I can try to contact them for you. You also have the opportunity, you have the option if you want to go forward without an attorney, but again, a free attorney is available to you today. All right, we're going to start the docket with Barbara Shaya.
Judge, I had a probable cause objections with regards to Ms. Shaya.
Sure.
It just
She's
says,
North Broward? Okay, there she is.
Yeah, Your Honor, she's at North Broward.
All right, thank you, Deputy. All right, go ahead, Mr. Broward.
Judge, it just simply indicates that she was standing out in a post office. It doesn't say it says that she was bothering customers, but it doesn't say what she was saying to them. There's nothing more there than other than she was on the corner of the property, where I guess she had been told not to go before. At most, it would be a trespass, but I don't believe that it is a disorderly conduct is the appropriate charge.
All right, Mr. Linder.
One moment, Your Honor. Well, then, yes, the court can find probable cause for trespassing. You're not bound by what's listed there. It does, the facts do give probable cause, noting that she has been trespassed. She was trespassed on the location 30 days prior.
All right. That's a good argument, and I agree. So I'm going to find probable cause for a trespass rather than for...
Excuse me, may I speak as a person? I know you advised not to, sir, but I was going to the bank when my phone rang. Literally, I have the two telephones.
Ma'am, this is a public defender. I would just ask you not to speak about the facts of the case. That's something that we can talk about later, okay?
Okay, but I wasn't on postal property. I was on the crosswalk when they came towards me, and he said, "You can't be on the crosswalk." So I said, "All right, one moment." I was trying to secure my phone and move away when the Hallandale police came and ripped me out of my wheelchair and stood me up and pushed me forward and said that I was being arrested. And I couldn't understand why. So I contacted Commissioner Annabelle, which was the third call I was supposed to make that day, and to let her know that I was going through the state attorney because said police officer stole my son's van. So it was rather complicated, sir. But I wasn't on the postal property because I was trespassed illegally off the postal property, whereas the postmaster, I was told, only has jurisdiction within the post office and not outside the post office, not the parking lot where she had me wait one time for my son to bring the key because the city lost my key and I simply did not have another $9 on me to buy another key, and I wanted my mail because I'm expecting a piece of mail from a judge. So
I understand.
I wasn't even on the post office. I wasn't on the postal sidewalk. I was actually on the crosswalk because they have a postal sidewalk. And the city stop sign shows, I tried to show the officers after they ripped me out of my wheelchair. It hurt immensely. I tried to show them. See that city stop sign and the street sign? I was on the opposite side of that. You wouldn't consider me on the swell because I was on the crosswalk.
Ma'am, you're going to have an opportunity at trial to testify about all this if you wish. I'm going to set a $25 bond for you, ma'am. You're going to go see Judge Lerner Wren. I'm going to transfer the case over to her division, and you'll see her very soon, okay? Good luck to
Thank
you. God bless
very
you.
much, because I have little ones to take care of. You have a blessed
All
day,
right,
Your Honor.
have a blessed day, ma'am. Take care.
Thank you.
Star Salvador.
Good.
Many people hanging outside. Outside.
Star Salvador.
North Broward again, Your
Oh,
Honor.
okay.
Come on, Miss Salvador. Inside the cell.
All right. Good morning. Good morning, Miss Salvador. You're being held on a misdemeanor warrant, ma'am, for a petty theft charge with a prior conviction. Bond has been set by your division judge at $1,000, and they'll set up a date for you to see him or her. Okay?
Yes.
Good luck to you, Miss Salvador. Feel good. Ashley Mejia. Mejia.
Back to the cell.
Is that an MO? I think, yeah, no.
Right there.
Sorry, it's a VOP.
Ms. Mejia is here present.
Very good. All right. Good morning, Miss Mejia, and I'm sorry for butchering your name the first time. You're being held for a violation of your felony community control. You're going to be held no bond at this time by order of Judge Duffy, and you'll see her October the 2nd at 9 a.m. to address that charge, okay? Good luck to you. Good luck to you, ma'am. Desiree Ventura.
Judge, you didn't require a Spanish interpreter for Ms. Ventura?
Sure, no problem. We'll call one now. I'm going to put that
Toma
case
asiento, por
aside.
favor.
All right, Yvette Smith.
Ms. Smith, come on up, please.
Ms. Smith, good morning. You're being held in a violation of your felony probation. You're going to be held without bond at this time, and you will see Judge Colra on October 3rd, 8:30 a.m. to address that, ma'am. Good luck to you.
Thank you.
Marcy Russell.
North Broward again, Your Honor.
All righty. Ms. Russell, good morning. You're charged with possession of cocaine, possession of drug paraphernalia, driving with a suspended license, failure to wear a seatbelt, and blocking an intersection or a crosswalk. I'm going to find probable cause for the offense. I see from the booking sheet that Ms. Russell is from Michigan. She have any other priors?
She does have priors out of the state of Michigan, Your Honor. 2014, possession controlled substance, cocaine, heroin, or other narcotic. Retail fraud, 2012. Retail fraud, 2009. Operating a motor vehicle while impaired, 2008.
Right. Ma'am, I'm going to set a $1,000 bond on count one, and the other charges, there's going to be no monetary charge. If you do go back to Michigan, ma'am, you are going to have to come back to South Florida to face these charges. Otherwise, a warrant may issue and you would forfeit that bond. All right?
Okay.
Good luck to you, ma'am. You take care.
Thank you. You too.
Valencia Weldon.
Wake up. The more you're going, I'm not gonna wake you up again.
Call Ryan, Judge.
Oh, she's in Ryan. Thank you. Thank you.
I guess, well,
No, I guess not.
either that or
All right. Yes, yes. I'm going to put her on
definitely
recall.
changing
No
the
problem.
mood.
And Jessica Scott.
I've been advised she bonded, Judge.
Bonded, okay, I'll find probable cause. Liberty Esposito,
North Broward.
North Broward.
all righty,
Kiefer.
excuse me. Oop. All right, good morning, ma'am. You're charged with possession of cocaine, possession of drug paraphernalia, and trespassing in an unoccupied structure or conveyance. I'm going to find probable cause for the offenses. I'm going to set a $1,000 bond on count one, and there'll be no monetary charge on counts 2 and 3. Do you want to do a little drug treatment while you're in jail? Do you want me to order the drug treatment program?
I don't know what that is.
There's a program called Substance Abuse Program. They offer it in the jail for free. You can go to some alcohol or Narcotics Anonymous meetings, other types of treatment meetings, things like that. It's a 30-day program. You don't have to do it, but I'm just offering it as a possibility.
I don't think so.
Not right now. Okay. All right. You
Not
take.
right now.
All right. You take care of yourself. Good luck.
Okay, what am I doing? How do I get out?
You got $1,000 bond, so you can put that up on a credit card or in cash, or you can contact a bondsman, and they'd probably ask you to pay them about $100, which is 10%, in order to have them post the full bond.
Okay, somebody mentioned the RLR.
Yeah. No, I'm not going to be able to do that today, but good luck to you, and I hope everything works out.
So the only way is the bond?
The bond, yeah. All right. Good luck.
All right, thank you.
All right.
Be on her way. When she gets there, we'll let the court know.
All right. Not a problem at all. Thank you. Brooke Bodie or Body?
Mr. Fuddy is here present at Maine, however, he just stepped out to the restroom, Judge. so
Oh, no problem.
they're on recall.
No problem. Richard Hellings?
Mr. Hellings is here present, he's our municipal ordinance case, Judge.
Got it.
Morning, Judge.
All right, good morning, sir. How are you? You're being held on 3 warrants for municipal ordinance violations of the city of Hollywood, carrying an open container of alcohol, 2 counts, and loitering where signs are posted, 1 count. Any priors, Mr. Linder, recent?
I just need,
765389, is this BCCN?
most recent was June 20th of this year. That was, Capias is on, 2 separate, no lodging on city-owned property.
All right. All right, sir, if you want to,
Excuse me, Your Honor.
Yes, yes.
I did that time, and then I'm doing community service now, and these warrants are popping out of nowhere. I'm not getting any dates. I set my own court date. I'm supposed to be in court this afternoon down in Hollywood. I was picked up yesterday.
Right.
Going to get another case?
Let me see.
do you want to resolve these cases today, or do you want to
I
go?
would like to resolve.
Okay, so if you want to plead no contest to all 3 of the charges today, I'll withhold adjudication. You'll just have to pay some court costs within a year, okay?
Okay, do I have any more of these? Are they any more gonna pop up?
I don't know. I honestly don't know. These are 3 warrants. It's okay to have a beer, but you got to have a beer inside. That's the thing. In Hollywood, in the city of Hollywood, you can't have one on the street.
Judge Davis, yes, sir.
So, we're all consenting adults here, and that's okay, but you gotta do it in a bar or in your home, not on the street, okay? Do you, is there somewhere that I can help you? Is there someplace I can send you? I see your address is the Broward Outreach Center, right? 2220 Scott Drive? All right.
20. No, I'm pretty well.
Oh, it's just a mailing address? Scott,
That's the mailing address.
all right. You wanna go over to the Outreach Center? I know them pretty well over there. It's a pretty good place.
No, sir, I'm pretty well, I take care of myself.
All right. Don't forget, it's okay to have a beer, just gotta be inside, not outside. Go ahead and raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
So help me God. Yes,
All
sir.
right, go ahead and put your hand down. Tell me your full name, Richard.
Richard Francis Hellings.
All right, Mr. Hellings, you're charged with 2 counts of carrying an open container of alcohol in public and loitering. Do you wish to plead no contest to all 3 charges?
I do.
You understand that by pleading no contest, you're giving up your right to have a trial?
Yes, sir.
Are you under the influence of any drugs, alcohol, or prescription medication that would make it difficult for you to understand me today?
No, sir.
All right, I'll find your plea to be knowing, intelligent, and voluntary. I'll withhold adjudication today. You're gonna have to pay court costs on count 1. I'll waive them on counts 2 and 3, and you'll have a year to do that, all right?
Yes, sir.
All right, you just take care of yourself. Try not to pick up any more of these, okay? Good luck.
I'll try.
All right.
Thank you.
Travis Shelton.
Judge, I've been advised Mr. Shelton is in Amport.
Oh, okay, all right. I could reset it to the afternoon, or I could reset it to tomorrow morning. Tomorrow's better, okay, so we'll reset
Trees.
tomorrow,
Trees.
Friday. John Carson?
Mr. Carson's here present, Judge, and Mr. Carson,
What?
he wishes to ask the court if you would
Yeah,
consider
but I'm
resolving
gonna be here.
the case. This is from an alleged incident that's
And if I could
targeted,
help,
and
I
believe the
would.
merchandise is recovered.
All right, let me talk to Mr. Linder here for a minute. So you are being held on a misdemeanor warrant for a petty theft. Any information on this, Mr. Linder?
One moment, Judge.
Thank you.
You have Carson on your list.
It's like the warrant.
He had One moment. Just need to check something. I just want to make sure. Anything else outside of Broward? Last year, he had a burglary, conveyance, and theft. He violated probation, was sentenced to 364 days. He also had a theft last year under the name Harry Gianfrancesco.
He had other petty thefts out of aid.
When?
Really, any resolution that I could offer today would involve probation, so I'm gonna send you over to the division, sir. You'll see the judge. It'll be a $500 bond. Good luck to you. Clifford
When
Freeman?
you get a chance,
Oh, yes.
Mr. Body is back from the rescue.
Yes, sir.
Oh, yeah, sure. Sure, we can.
Yes, sir.
Mr. Freeman, hang on 1 second. There's just one case in the main jail I'm gonna handle. I'll come right back to you, sir. All right. Mr. Body, come on up, sir. All right. Let's see, you're charged with loitering or prowling. I'm gonna find probable cause for that charge. It's an interesting fact pattern here. Mr. Linder, does he have any other priors?
Yes, Judge. As far as state priors in Broward, he had a resisting without violence and exposure that he pled out August 17th. Resisting without violence last year, trespass 2015, violation of county ordinances 2014.
Mr. Body, he wishes to ask Your Honor if you would consider resolving this case today.
All right. I can't really tell what's going on here.
Yes, Judge.
Mr. Body, let's see, are you staying at the Broward Outreach?
You can put it up on there.
I was.
You were,
He was, and I believe right now he is homeless, Judge.
okay.
So,
And what was, you said, what did he just pled something out in August, yeah?
It was a
That's money, buddy.
resisting without an exposure.
It's a very odd fact pattern here. All right, sir, I'm gonna let this go to the division. It's just gonna be a $25 bond today, sir. Good luck to you.
Judge?
Yes.
In the alternative, considering this is, I haven't had an opportunity to review the probable cause affidavit, but looking at it, it's a second-degree misdemeanor, non-violent, would you, and he's financially indigent, he is homeless, would you consider an ROR?
That,
I believe the last offense that he picked up was a misdemeanor. I believe it was urinating in public, and before that, I believe from what Mr. Lender said, his last prior was last year. And so it doesn't seem like we're dealing with a person with an extensive criminal history, Judge.
no, I agree. This could have been charged potentially as a bird conveyance, the way I'm reading the probable cause affidavit.
And Your Honor, and I imagine, just from experience, the reason either a grand theft auto or burglary was charged, they weren't able to get in touch. It wasn't reported, and they weren't able to get in touch with whoever the owner is of the vehicle.
Yeah, I
But that
think-
he's giving a different name than the person who's.
I think in this case, I'm more comfortable keeping a monetary bond in place. Good luck, $25 bond, sir. You take care.
Your Honor.
Yes.
Paul Ryan has the defendant Welder.
Oh, okay.
Thank you, Deputy.
All right, thank you. Good luck, sir. All right, let me go back to Paul Ryan for a moment. We don't want to get too far out of order. All right, good morning, good morning. Oh, no problem at all. All right, Miss Weldon, let's see, you're charged with possession of cocaine and operating without a valid driver's license. I'm gonna find probable cause for those offenses, ma'am. And, bond will be $1,000 on count 1. There'll be no monetary charge on count 2. All right? Good luck to you. All right, let me go back to North Broward here. That's Freeman. I'm Clifford Freeman. Hi, Mr. Freeman.
Yes.
I'm sorry to make you wait there, sir.
You're right. You're right.
All right, sir, you're charged with a petty theft in the second degree.
I didn't steal anything, I never left the.
Sir, don't talk about the facts of the case, okay?
Huh?
This is the public defender, don't talk about the facts of the
Yeah,
case.
don't talk about the fact you have the right to remain silent. I am going to find probable cause based on the affidavit. Does he have any other priors?
One moment, Your Honor. He had a battery out of Broward, with the resisting without violence in 2015. My system's not loading up, so I can't tell if he has anything else.
All right. According to the probable cause affidavit, the drink was recovered. I heard what you said, that you didn't steal anything, so I'm gonna give you two choices today. You tell me what you wanna do. Either I'll release you on your recognizance, so no monetary bond, you'll get out of jail and you can fight the case. If you wanna plead no contest to the case today, I will resolve it, withhold adjudication, and you'll have a year to pay some court costs. Those are just the choices. I'm not recommending one or the other. The choice is totally up to you and your attorney.
Yes, sir. What did you say I completed?
You can either, if you want, I'll release you on your recognizance. You'll have to come back on another court date. They'll send this to a division judge. You'll see he or she, and
Okay, release.
you'll go forward. Or if you want to plead no contest, I'll withhold adjudication. You'd have to pay some court costs.
Release me on my on
You got it. So I'm going to release you on your recognizance. Now, you got to come back to court. So
Yes, sir.
the address they have here on the booking sheet is at large. So do you have a place where they can send a court notice? Because if you miss the court date, they're going to issue a warrant for your arrest.
Yes, sir.
Where should we send the court notice?
To my sister's house.
Okay, can you tell me your sister's address?
5238 2nd Street,
What city, sir?
Fort Lauderdale.
Fort Lauderdale, okay. Do you happen to know the zip code?
No, sir.
Okay.
I don't know.
I think the clerk's office can look that up. Did you,
All right.
did you get that? You able to get that? Oh, yeah, right. Do you know if the direction of the street, northwest, southwest, anything like that?
Northwest.
Northwest. Okay. Did you get that, or do you need him to repeat it one more time? Can you repeat the address one more time, just for my clerk? She's writing it down.
5235 Northwest.
Northwest,
Yes, sir.
which,
I know.
Oh.
Northwest Second what?
all right, the address changed. Say it one more time, Mr. Freeman. The whole address, the whole thing.
I'm pretty sure that was it, sir. 5235. 5235.
5235. The whole thing,
5235 North 2nd Street.
No, it's North Second Street.
All right. We don't know where to send this notice, so,
Judge, what I would ask, there's sir, do you have access to a computer? Could you look it up if you were online and see when your next court date is?
at the library, something like that. How you doing, Lorianne? Good to see you.
Sir, would you be able to do that, look it up on a computer to find out when your next court date is?
Will I be able to look it up?
Yes.
Yes, sir.
Okay. And the second thing is that once you get out, if you find the address is incorrect that you gave, maybe you transpose some numbers or something like that, will you make it a point to come to the clerk's office to give them the correct address, have it written down so that they'll know? That way you get your notice and don't end up back in jail.
Yes, sir.
Okay.
Because I can tell you, as of right now, my clerk has no idea where to send the notice, so there's not gonna be one sent in the mail.
All right, sir.
You've gotta check, otherwise there's gonna be a warrant, and guess what? You're gonna wind up right back in jail, okay?
All right, John.
All right, God bless you, Mr. Freeman. You sure you don't wanna take care of the case today? The other option is to plead no contest.
You mean you can take care of the case today?
I can take care of the case today.
Yes, let's take care of it today.
Okay,
Because-
all right. That way you don't have to worry about any of that, okay?
Yes, sir, because, yeah, after good time served and be released anyway, since I didn't take anything.
Okay.
All
Well,
right, yes, sir.
all right.
It,
I need
All right,
his
raise your
paperwork
right hand for me.
back. I need his paperwork back.
Do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, go ahead and put your hand down. Tell me your full name, Mr. Freeman.
Clifford Earl Freeman.
All right, Mr. Freeman, you've been charged with a petty theft in the 2nd degree. Do you wish to plead no contest to that charge? No contest means I'm not finding you guilty, but I'm finding that there was enough evidence there for me to make a finding. Okay?
Yes, sir.
Okay. You under the influence of any drugs, alcohol, or prescription medication that would make it hard for you to understand me today?
No, sir.
All right.
No, sir.
All right, I'm going to find your plea to be knowing, intelligent, and voluntary. I'm going to withhold adjudication today. You'll have a year to pay the court costs. They'll give you the information about that. And now you're all done. There will not be another court date on this case. The case is done, and you don't have to worry about it, okay?
Your Honor.
Thank you. Thank you,
Your
Your Honor.
Your Honor,
Yes,
the
Mr.
only thing I would ask is that, court order, he not
yeah.
return to the, I believe it's a Starbucks. Was it a Starbucks or?
I don't think it's a.
Oh, I'm sorry,
I
was
think
it
it's a
some other?
I think it's a convenience.
Okay, I
store.
wasn't sure.
It was a Starbucks drink, but I think it was a convenience.
Okay, that's how I got it.
So you can't go back to this convenience store on Pembroke Road in Hallandale, at 200 East Pembroke.
I saw
You
that. I saw
can't-
it said
You
Starbucks
can't go
drink,
back
so
there,
I-
okay?
Yes, sir.
All right, good luck to you.
Judge, if I can just ask him one question?
Yes.
Sir, I know you keep saying that you didn't do it. Do you feel that this plea is in your best interest? It's best for you to just resolve it today so you don't have to come back to court?
Yes, sir.
Okay, great. Thank you very much. Thank you, Judge.
All right, take care of yourself, sir. Be well.
All right. Thank you. Thank you, Your Honor.
Guy on the kidnapping case. This guy on the kidnapping case. Oh yeah, he had a robbery firearm, 2003.
Sure, oh, yeah, absolutely.
Yeah.
Do you
he
need
was
it on the
sentenced to-
original also?
So I'm like, oh, well, he was sentenced to 15 years, so he just got out in June of this year.
I put it on the September 12th.
The 27th, that was yesterday.
Oh, I put the 2 in the wrong place. 2-7. 2. Okay. Any question about it, they can just call me, but yeah, absolutely release him. All right, Greg Lamberti?
North Road again.
All right, good morning, Mr. Lamberti. You're being held on a traffic warrant. Was this warrant issued while he was in custody? Does anyone know?
Well, Your Honor, it's a little different because it's one thing if he's in local custody.
But he's in
In the
state.
satellite, he was in state prison.
Is he released now from state prison? Since he
I
only
imagine
told me?
that's why his release date is Monday.
All right, well, you got a really old traffic warrant. If you want to plead no contest to it today, so nothing holding you up,
I'm just checking his
we can
record.
do that, if that's something you want to do.
Yes, sir, Your Honor.
All right,
I just want to check his driving record real quick just to make sure that.
right, that I won't habitualize him. All right. Hang on one second, we just want to make sure there won't be any negative consequences to you taking the plea.
Now, from what I can tell, it looks like this will be a first.
All right, so you're all right. You get 3 of these suspendeds in a 5-year period, they can charge it as a felony, so this is just one,
Well,
okay?
Your Honor, just because I just want to make, if he gets 3 in a 5-year period, his driver's license could possibly be suspended for up to 5 years. If he picks up 3 in a lifetime, the third could be charged as a felony.
Oh, it's 3 in a lifetime.
Yes.
All right, did you hear that?
Yes, sir, Your Honor.
So just don't drive with a suspended license, okay?
Yes, sir.
All right, good deal. Go ahead and raise your hand for me, Mr. Lamberti. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
All right, go ahead and put your hand down. Tell me your full name.
Greg Anthony Lamberti.
All right, sir, you've been charged with driving the suspended license. Do you wish to plead no contest to that offense?
Yes, sir.
Do you understand that by pleading no contest, you're giving up your right to have a trial in this case?
Yes, sir.
Are you under the influence of any drugs, alcohol, or prescription medication that would make it hard for you to understand me today?
No, Your Honor.
All right, I'm going to find your plea to be knowing, intelligent, and voluntary. I'll withhold adjudication, and good luck to you. You're going to have to pay the court costs, so you have a whole year to pay that, okay?
Yes, sir.
All right, good luck to you. You take care of yourself. All right. Morning, Mr. Jellin, how are you? And I'm so sorry, I saw you sitting there, but I forgot to call this the Spanish case. So, Bill, do you need a few minutes to review your paperwork, or you're good to go?
I have to see it too.
Go ahead. Yeah, take a few minutes. I'm going to call the Spanish cases, and then I'll call you. All right, how are you? Everything good?
Doing well, thank you.
All
How are you doing?
Doing great. Who are the defendants that needed, oh, right, we already called it. It was Desiree Ventura, wasn't it? All right, I'm going to recall Desiree Ventura.
Miss Ventura, come on up. Ventura. El intérprete está ahí, escucha por favor.
All right, good morning, ma'am.
Buenos días, señora.
I'm Judge Davis.
Soy el juez Davis.
I just have to swear in the Spanish interpreter.
Por el momento voy a juramentar al intérprete en español.
So if you could just raise your right hand. Do you swear or affirm to accurately translate from English to Spanish and Spanish to English to the best of your ability?
I do.
And just tell us your full name.
Martin Vidal, V-I-D-A-U-D.
All right. Ma'am, you're being held on a violation of your felony probation.
Señora, la tienen retenida a causa de que usted quebrantó su libertad probatoria por un delito grave.
You are scheduled to see Judge Michael Robinson,
Usted ya está fijada en calendario para ver al juez Michael Robinson
October the 3rd,
para el 3 de octubre
8:30 a.m.
a las 8:30 de la mañana.
He is going to address the alleged violation.
Él hablará con usted sobre la supuesta quebrantadura de la libertad probatoria.
Do you understand, ma'am?
¿Entiende usted, señora?
No.
She's in, I guess she did a motion, indicating she didn't hear the interpreter.
Can you give me the indication?
Sure. Do we still have the phone? Did they keep the phone system in place, or they still have the long cord? We can do
No,
it.
I think if he just goes closer to the microphone, she'll be able to hear.
Okay.
Trataré de hacerlo más cercano al micrófono.
¿Tú me puedes decir?
Can't you tell me? Can't you tell me?
Who?
I believe the interpreter believes that she's speaking to counselor standing next to her.
He can tell you, but I have to make sure that you understand. It has to come from me. It has to come from the judge.
Él se lo puede decir, pero yo tengo que asegurarme de que usted entienda. Por lo tanto, eso tiene que surgir del juez, tiene que venir de mí.
So are you able to hear the interpreter?
¿Puede usted entonces oír al intérprete? What?
Sí.
Yes, yes. No, no. No, no.
Mr. Romero, do you mind asking her in Spanish if she has a hearing difficulty or if it's just that there's too much noise?
Okay, I will.
Thank you.
She says it's not a matter of, I guess, she says she can't really hear the interpreter. She also told me maybe
Yo lo entiendo, yo lo oigo, pero a él, al intérprete no.
she
She
hears,
says-
I guess, the sound from the
Excuse
judge,
me.
but she doesn't hear the interpreter.
Martine, you want to come up here and use this microphone?
If you would rather.
It's okay with me. Or if you want to use Mr. Farber, you can try Mr. Farberic's microphone.
A ver, ¿me oye?
No, un poquito.
A little bit.
All right, so come use mine. Come use mine.
Okay.
She can hear me. Should I go around? Doesn't matter. Here, you can come through this way if you want. It's not locked. So the interpreter's going to come up here. All right, you're going to be able to see him. Okay. Here you go, Martine. So you just tell her she's being held for violation of probation.
La tienen retenida acá por haber quebrantado su libertad probatoria.
She's going to see Judge Robinson.
Usted comparecerá.
I don't know what else he can do.
I believe now what she's informing me is she doesn't understand the interpreter. I guess from what I think what she indicated, his voice is kind of muffled.
Martine, just talk loud, I guess. Loud.
La tienen acá retenida porque quebrantó su libertad probatoria.
Ahora sí.
Now I can.
Hable sin miedo.
Okay.
Talk without fear.
All right. Good. All right.
Muy bien.
So she's being held for a violation of her felony probation.
La tienen retenida por haber quebrantado su libertad probatoria de delito grave.
She's going to be held no bond.
La van a tener retenida sin fianza
She's going to see Judge Robinson
y va a ver al juez Robinson
October 3rd,
el 3 de octubre
8:30 a.m.
a las 8:30 de la mañana.
Ajá.
¿Entiendes? Understand?
¿Ha entendido?
¿Entendiste?
Entendí.
She
I
said.
understood.
All right. Bueno. All right. Very good. Thank you, Martine. Thank you very much. All right. Good luck.
Buena suerte.
There was one other gentleman, Judge, that requires Spanish interpreter. He would be on page 16 of your docket, so
Sure.
I guess towards the back half of your stack. And his name is Mr. Brian Lozano.
Lozano. Martine, you're famous now. We've got to order the video.
This.
Lozano.
Lozano. Hay un intérprete en español.
Lozano, okay, Brianne Lozano.
Brian Lozano.
Okay. All right, sir, I'm Judge Davis.
De acuerdo, señor. Yo soy el juez Davis.
Are you able to hear the interpreter?
¿Puede usted oír al intérprete? Yes.
All right, good.
De acuerdo, bien.
If at any time you're not able to hear the interpreter because there's a lot of noise in the background, I need you to tell me or tell your public defender immediately.
Si en algún momento usted no llega a escuchar al intérprete porque hay mucha bulla en el fondo, necesito que le diga inmediatamente, me diga a mí y que le diga a su abogado de oficio inmediatamente. ¿De acuerdo? Okay.
All right, sir, you are charged with a robbery with a firearm.
De acuerdo, señora. Usted se le acusa de asalto con arma de fuego.
I'm going to find that there was probable cause for this offense.
Fallaré de que hay fundamento de hechos para este delito.
Let me turn to the state attorney.
Yes.
Ahora voy a dejar que hable el abogado fiscal.
Your Honor, the state is going to be seeking a no bond hold pursuant to Isaza v. State.
Su señoría, en conformidad de Isaza contra el Estado, la fiscalía va a estar buscando de que se le retenga sin fianza.
I believe the court is familiar with the allegations. We had one of his co-defendants yesterday morning.
Yo creo que el juez ya conoce los hechos del caso, ya que tuvimos los alegatos del caso, ya que tuvimos el coacusado aquí ayer.
Your Honor, stop. We have top of the case. Your Honor, the allegations satisfy the elements of robbery with a firearm.
Su señoría, los alegatos satisfacen los elementos que constituyen el delito de asalto con arma de fuego.
Mr. Lozano was identified by someone that knows him personally.
El señor Lozano fue identificado por una persona que le conoce personalmente.
From video surveillance that was taken from a neighboring business, taken at the time of the robbery.
En el momento de el asalto, del robo, también hubo video de un negocio vecindario que captura a la imagen del caballero.
And lastly, the report alleges that Mr. Lozano made a confession to his involvement in the robbery post Miranda.
Y también el alegato dice que después de que se le leyeron los derechos bajo Miranda, el señor Lozano hizo una confesión en cuanto a cómo estaba involucrado él con el robo.
All right, I'm going to turn to the public defender's office who's here with me in the courtroom for response.
Ahora permitiré que el abogado de oficio, quien está aquí dentro de la sala del tribunal conmigo, responda.
Judge, we would just argue at this point that there's only a probable cause affidavit that's in front of the court, that I
Pues,
don't believe that. I'm sorry.
Pues en este momento entonces vamos a arguir de que hasta este entonces solamente hay un documento, un informe de fundamento probado frente al juez.
The probable cause affidavit indicates that the gentlemen that committed the crime were masked at the time.
El documento juramentado en cuanto al fundamento de hechos declara de que los que cometieron el delito todos estaban enmascarados cuando se cometió el delito.
And although he was identified through a video that was taken, we don't know what the clarity of the video is. We don't know how good the video is. And if it's something that somebody would be able to positively identify somebody who may look like him.
Y aunque hemos entendido de que fue identificado mediante video, realmente no sabemos qué tan claro está el video, qué tan buena es la calidad del video y si se le puede identificar en el mismo.
With regards to the admission that he made, there's no indication that there was any kind of interpreter that was with him at the time. Clearly, he speaks Spanish, so I don't know what happened as far as that goes. It's not indicated in the probable cause whether an interpreter was present, if he understood English.
En el documento de fundamento de hechos no se establece que aunque el caballero haya dado una admisión, si esa admisión fue mediada mediante un intérprete, si hubo alguien, o sea, es obvio que la persona no habla español, que no habla inglés, y no sabemos si en ese entonces hubo alguien que le pudiese interpretar.
Based on that, Judge, I don't know that it would rise to the level of proof evident presumption great.
Basado en eso, no sabemos si surge a tal nivel donde dice que las pruebas son evidentes y la presunción grande.
And we would ask the court to set a bond in this case.
Por lo tanto, le pedimos al juez que fije fianza en este caso.
Thank you, and I'll note also that the probable cause affidavit states the defendant was identified by an independent witness who knows him.
También quiero hacer nota de que la declaración juramentada dice que el acusado fue identificado por un testigo independiente que lo conoce.
Based on the totality, I'm going to find for bond purposes, there is proof evident or presumption great to hold you, sir, without a bond at this time.
Dada toda la totalidad de los hechos, yo creo que en este momento puedo establecer de que las pruebas son evidentes y la presunción grande para poderlo retener a usted sin fianza en este momento, señor.
You will have an opportunity to have a bond hearing
Sí que tendrá la oportunidad de tener una audiencia de fianza
before your division judge.
antes de que comparezca ante el juez de su sala de lo penal.
I'm also going to order that you not return
También le voy a ordenar de que no regrese
to La Mexicantina
a la Mexicantina,
store
la tienda esta,
until further order of the court.
hasta que el tribunal ordene de manera diferente.
All right, good luck to you, sir. Take care.
De acuerdo, buena suerte, señor. Cuídese.
Oh, I will. All right. So, wait, sir. come
Espere,
back.
señor, regrese.
Hector, could you ask him to come back, please? All right, sir, I also have to advise you so that you know
También le tengo que asesorar, señor, para que usted sea consciente
that the federal government has issued an immigration hold for you
que el gobierno federal ha expedido una orden de retenerlo por motivos de inmigración.
that's going to be handled by a federal court, not by the state courts.
Será un tribunal federal que lidiará con ese asunto, no el tribunal estatal.
But if you do receive a bond in this case, you will still remain in jail until the federal government makes a decision about that immigration hold.
Pero si usted fuese a ser dado una fianza en cuanto a este caso, permanecerá en cárcel hasta tal entonces que el gobierno federal decida qué harán en el caso suyo.
All right. Good luck to you, sir.
De acuerdo, buena suerte, señor.
Martine, thank you so much.
You're very welcome. Thank you, Your Honor. You guys have a good morning.
All right. You have a great morning.
Your Honor, if we could call a case at a turn, please.
Sure. Did Mr.
Travis Watson, I think it's at towards the very end of the document.
Sure. And did Mr. Jones?
Yeah, I guess I had to step out
Yeah,
for
just
him.
step out. All right, no problem. When he comes back, I know you detectives have been waiting a while. We'll get that. What was the name of the case? Watts?
Travis Watson.
Oh, okay. Yep. Yep.
It's like the fourth from the bottom.
Yeah, no, I had noted that one. All right, Travis Watson, please.
And,
Mr. Watson,
Your-
still present, Judge?
Your Honor, could,
Is I hear correctly as counsel, Mr. Bill John?
no, that's a different.
That's for Jordan Little. Jordan Little has Mr. John. And Mr. John's here. He just had to step out just for 1 minute.
Your Honor, could, Mr. Farberg and myself please approach briefly?
Sure. You want me to go sidebar?
Yeah, if you actually go, if you hit juvenile, that make sure it doesn't go out on there.
On the record. Let's see here. Mr. Watson, sir, you're charged with the following offenses: robbery without a firearm or weapon, kidnapping, failure to report a death to the medical examiner, and 2 municipal ordinance violations out of the city of Hollywood. Right off the bat, I will tell you, sir, on the municipal ordinance violations, I'm going to appoint an attorney to represent you free of charge. That attorney's name is Stephen Shate. Those cases will be handled by a misdemeanor judge, and Mr. Shate will be with you whenever you're brought down before that judge. I do have 2 detectives here from the city of Hollywood who I think are intending to testify today. So I'm going to ask you each to raise your right hand for me And do each of you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
I do.
All right, and if you could each, I'll start with you, Detective, just tell me your first name, your rank, I'm sorry, your full name, your rank, and the agency you work for.
Sure. Desiree McClintock. I'm a homicide detective with the Hollywood Police Department.
All right, and also you, Detective.
Sean Keogh, homicide detective with the City of Hollywood Police Department.
All right, very good.
And-
Mr. Linder?
Actually, Your Honor, and I don't have any objection if the court has any questions to inquire. Upon reviewing of the probable cause affidavit, I do not have any questions for Detective McClintock and Detective Keogh. On count 2, which is a punishable by life offense, the state is going to be seeking a no bond hold under USAZA v. State. Your Honor, I'm going to be relying upon the probable cause affidavit prepared by Detective McClintock, which I believe is very specific and very thorough. Your Honor, specifically mentioning the physical evidence that was located by law enforcement at the scene of the offense, detailed information providing how Mr. Watson was identified as a suspect and located, and finally, Mr. Watson's post-Miranda confession, Your Honor, that, one moment, Your Honor, which states with great specificity his involvement in the allegations that form the basis of the charges on counts 1 through 3.
Well, Detective, you did a very good job with this probable cause affidavit. It's very detailed. It's very chilling. If there is anything that you feel you need to tell me that is not in the probable cause affidavit, I'm happy to hear it. But as I said, it's very, very detailed. Mr. Farbarak, of course, I'm going to allow you to make argument, but I'll let the detective, if there is anything you wanted to add, I'm happy to hear it. Have you been in touch with the victim's family?
Yes, sir.
And they're, okay. All right. All right, yeah.
Well, no, I will wait for the court to make a finding as far as count 2 before I proceed on count 1.
All right, Mr. Farbarak?
Judge, the only thing that I would argue on behalf of the defendant is that with regards to count 2 only, is that it's a kidnapping charge. Basically, they were invited back to this house, that the gentleman had them there freely, that they were allowed to be there, and that it doesn't ever indicate, I know that there are different things with regards to my client's involvement and the things that he alleged or that were alleged against him, and that I don't know that it would rise to the level, and we would ask the court that just to set a bond in this case. I don't know that it rises to the level of kidnapping.
Right. Thank you, Mr. Farbarak. And so I'll note, I agree with you in terms of that there was a consensual invitation at one point during this incident to allow the defendant into the home. There came a time when that invitation was revoked, and allegedly the victim was, well, without going into too much detail, was essentially kidnapped by the defendant and the co-defendant, at least in a legal sense. That's what I find today. So, sir, I'm going to make a finding, at least for bond purposes, for first appearance purposes, that the proof is evident or presumption is great, to hold you without bond on count 2, which is a kidnapping charge. And you will have an opportunity to have a bond hearing in front of your division judge, an Arthur hearing. The state will call witnesses. The defense can call witnesses and also can cross-examine. Let me ask about Mr. Watson's priors with an eye towards setting a bond on count 1.
Your Honor, the state is going to be seeking a $100,000 bond on count 1. I believe Mr. Watson poses a significant risk to the safety of the community. That is not based only on these allegations, but also his criminal history, Your Honor. In 2003, Mr. Watson had a burglary of a structure at a Broward. Actually, I'm sorry, Your Honor. All out of 2003, he was convicted of 5 burglaries of structure, 2 counts of grand theft, 1 count of grand theft firearm, and 1 count of possession of burglary tools. He was also convicted of strong arm robbery. On the strong arm robbery, he was sentenced to 15 years state prison, 6 years and 2 months on all the other charges. Your Honor, Mr. Watson was just released from Florida State Prison June 1st of this year.
Okay. All right. Mr. Romero, anything to add as to bond?
Judge, the only thing I'd ask you also to consider in reference to count 1 and setting a reasonable bond is, unfortunately, Mr. Watson is financially indigent. but however, he was born and raised in South Florida, and I'd ask you to take that into consideration, that he's been here almost his whole life, and that he is financially indigent, Judge.
All right, I understand. Sir, I am going to grant the state's request for a $100,000 bond on count one. I am going to order that if at some point you do receive a bond, you be on pretrial release, level 1, that's a house arrest with a GPS monitor affixed. There is a co-defendant in this case. I'm going to order that you have no contact with your co-defendant and any witnesses involved in the case, sir. Good luck, and God bless you. Take care.
Judge, at this time also, we'd be invoking Mr. Watson's right to remain silent and not be questioned by law enforcement relating to any sort of criminal investigations, Judge.
All right, so noted. The detectives are here and they're aware. All right, thank you very much. Good luck. Thank you, detectives. Thank you for
Thank you,
coming
sir.
in. Nice to see you. Does anyone know where Bill went? Did he just step out in the hall, or he had to go to a different courtroom?
I'll give him a call.
All right.
Yeah, you left count 3 ROI.
Account 3 ROR and, yeah, $100 bond on the municipal. All right.
Placing him on pretrial on the felony.
Correct, just the felony count. I'm not concerned as to pretrial about the other counts. All right. Johan Hernandez Polanco.
More trial, Your Honor.
All righty. Sorry about that. All right, good morning, sir.
Good morning, sir.
You're being held on 3 misdemeanor warrants for municipal ordinance violations. They're all carrying an open container of alcohol in public. Any recent priors, Chifa? 695, 657?
Sorry, what's the last name, Your Honor?
His name is Hernandez Polanco. I only asked you because Eric was on the phone, sorry. 695-657 is his BCCN number. Thank you. These are pretty old. October 2016, December 2016. There's one from April of this year.
695-657?
Yeah.
Nothing this year.
All right. Mr. Polanco, these are a few months old. Some of them are a year old. So if you want to plead no contest to all 3 charges today, I'll withhold adjudication, and you'll have a year to pay some court costs. Okay? You want to do that?
Yes, sir.
All right. I told somebody else earlier today. I'll tell you, it's okay to have a beer. Nothing illegal about that. You just got to do it indoors in a bar in your home. Can't do it on the street. Okay?
I promise.
All right. Go ahead. Go ahead and raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, yes, sir.
All right. Go ahead and put your hand down and tell me your full name.
My name?
Yes, just your whole name.
Johan Hernandez Polanco.
All right. Mr. Polanco, you've been charged with 3 counts of carrying an open container of alcohol. Do you want to plead no contest to those charges?
No contact.
Okay. You understand by pleading no contest, you're giving up your right to have a trial?
Yes, sir.
All right. I'm going to find your plea to be knowing, intelligent, and voluntary. I'll withhold adjudication, and you'll have a year to pay court costs on count 1. I'll waive them on counts 2 and 3. Good luck, Mr. Polanco. Take care of yourself.
Sir.
Yes,
one
sir.
question.
Yes, of course. Yes.
I live in the street for 4 years. I don't got no family here. You know, I'm not homeless. I'm gonna try to do my best.
Let me ask you a question. Where are you from originally? I mean, in the United States. Do you have family anywhere in the United States?
Yeah, my mom Puerto Rico and my dad Dominican.
Well, I'm praying for your mom and for your dad right now. I know that those islands were very badly damaged, so I hope they're okay. Do you have any other family anywhere else in Florida or the United States? Because the city of Hollywood will reunite you with them if you want to for free.
Yeah, yeah.
But only if you can go see their community resource officer. They'll give you a free ticket to go see them, a bus ticket. The other option is Hollywood's got a really good outreach shelter. I've been there numerous times to talk to some of the people that live there. The Broward Outreach Center, you know it, on Scott Street.
Yeah.
There's also one in Pompano that's within walking distance of North Broward Jail. It's really close.
All right.
You want to,
Okay.
so if you want to try it out, they'll give you a map there at North Broward.
Okay.
Okay?
I'll do it.
All right.
Yeah.
All right. Good luck to you. All right. God bless you. Take care of yourself.
Okay.
Guys, I'm just taking a very quick recess, maybe less than 5 minutes, okay? Much. Okay. Next up is going to be Patrick Lanier. All right. Good morning, Mr. Lanier. I'm Judge Davis. You're charged, sir, with 2 counts of battery. These charges are violations of municipal ordinance out of the city of Fort Lauderdale. I'm going to appoint an attorney to represent you free of charge. That lawyer's name is Jara McLawrence, and he's here today to represent your interests. Excuse me, I am going to find probable cause for the offenses. Mr. Lanier, any priors for Mr. Lanier? Excuse me. 157142 is his booking number.
Last arrest in Broward was January 2015.
Okay, but no other recent batteries, things like that?
No, that was his last arrest, and that was on an open container.
Open container, okay. All right, Mr. McLawrence?
Judge, I did try to make contact with the city prosecutor. I was unsuccessful in receiving response.
Yeah.
I'm not sure what the court wants to do as far as a resolution is concerned. If the court wants to resolve, then I'm sure Mr. Lanier would appreciate that. If not, Judge, I thought that the amount of the bond for Mr. Lanier is high. I doubt that he'd be able to make $2,000 worth of bond, so I was going to request that the court reduce the bond to an amount that he could afford or release him on his own recognizance.
All right, I agree with you as to the bond, so I'm definitely going to ROR count 2, so that leaves us with count 1. What do you think Mr. Lanier might be able to afford just based on talking to him? Anything?
Judge, I haven't had an opportunity to discuss anything with Mr. Lanier before coming to court today. I was running behind.
No, that's no problem at all. Mr. Lanier, you think you could afford maybe like a $50 bond? 50?
I don't have anything right now.
No money?
I'm on disability benefits and pretty close to get my benefits, but I'm stuck right now, Your Honor. The lady provoked me.
Okay, stop talking, Mr. Lanier. No one asked you all that.
So you're on disability benefits already, or you're waiting, you're hoping to get disability benefits?
No, I'm on it.
How much do you receive in disability per month?
About $742 or something like that. $742.
Okay.
In between the first and third.
All right, I'll reduce the bond down to $50 to assure your appearance, sir, and I'm going to order that you have no contact with either victim in the case. Their names are Emily Ormiston and Deborah Skinner. So you have to stay at least 500 feet away from those 2 ladies. You can't call, text, write, email, or try to find them in any way on social media. Do you understand that?
Yes, sir.
All right, good luck to you, sir. You take care.
Thank you, Judge. That's all.
All right, Mr. McLawrence will be in touch with you, or you be in touch with Mr. McLawrence, actually. There you go. All right, any other, that's all, no other MOs for you? All right. Brett Temple?
Good morning, Your Honor.
All right, good morning, Mr. Temple. You're being held on a misdemeanor warrant for a battery, sir. I'm going to find probable cause for the warrant, and there's a $500 bond attached to that. You'll see the division judge very soon, okay? Good luck to you.
I'll call your brother just like we talked about, okay? Okay.
Mark Graber.
Mr. Graber is here approaching judge. He's advising if his parents are, he told me that his parents are bonding him out. May we
Okay.
inquire if his bond has already been posted?
Sure. L'Oreal, do you know if that's been posted? We're just checking. Sir, I am going to find probable cause for the charges.
No, not this time.
All right, not yet, but sometimes it takes a little while for it to show up in the system. So it's a $100 bond, and as you said, your parents are going to post it, okay? Good luck.
Good luck. Thank you.
Franklin Respress.
Mr. Respress is here present, Judge?
Okay. All right, Mr. Ooh,
Oh, wait, hold on one second. He was here.
he was. Maybe went to the restroom.
He's approaching.
There we go. All right, good morning, sir. You're charged with carrying an electric weapon or device, possession of cannabis, and possession of drug paraphernalia. I am going to find probable cause for those offenses. He's out on pretrial release right now?
He's he's out on bond.
bond.
Leaving the scene of an accident with injury.
All right. Any other priors?
One moment. I know, we're having issues this morning. One moment. Looks like he successfully completed misdemeanor drug court for possession of cannabis on August 24th of this year.
All right. All right, sir, I'm not going to revoke your bond in the other case at this time. Doesn't mean the state is not going to seek that with your felony judge. That's really going to be up to them. I'll leave it $100 bond on count 1. No charge on counts 2 and 3. You're not to possess any weapons, firearms, or ammunition, sir. You understand?
Yes, sir.
All right, good luck to you. Take care of yourself. Johnny Velasquez.
Copy.
All righty.
He said I'll be there for business.
All right, good morning, sir. You're being charged with a violation of your felony probation. You're going to be held without bond at this time, and you'll see Judge Merrigan October 9th, 9 a.m. to address that charge. You understand, sir?
Yes, sir.
All right, good luck to you. You take care. Vincent Capone.
Copy.
Huh? All right, good morning, sir. You're charged, I'm doing well. You're charged with burglary of an occupied dwelling, grand theft between $300 and $5,000, and burglary of an unoccupied dwelling unarmed. These are counts 6, 7, and 8. I am going to find probable cause for these charges. Is he being held on 1 through 5?
Your Honor, he's got, on charge 1, it's a delivery of heroin within 1,000 feet of a place of worship or convenience business. He's got a $7,500 bond. He had bond surrenders on a misdemeanor theft and some MOs. And he's got these 3 charges. His history includes resisting without violence, 2015, resisting without violence, 2014, possession of heroin, resisting without violence, leaving the scene of an accident, 2013, possession of cocaine, 2013, burglary of a conveyance with a VOP, 2010.
All right, all right. All right, sir, I'm going to set a,
Oh, and I'm sorry, Your Honor, I think, and if you said this already, I apologize. I believe count 8 is actually burglary conveyance.
oh, no, I didn't say it, but you're right. Burglary conveyance, not an occupied dwelling. All right. So I'm going to set a $7,500 bond on count 1, $1,000 bond on count 6, $1,000 bond on count 7, $5,000 bond count 8, and you're to have no contact with any of the alleged victims in the cases. Good luck to you, sir. You take care of yourself.
Thank you.
Jordan Pinkney.
Conti.
All right.
I just want to know what time.
Mr. Pinkney, good morning. You're being held on a felony warrant issued by Judge Tim Bailey. He set bond at $1,000 on that warrant, sir, and you will see him on October the 2nd, 8:30 a.m. to address the charge, okay? Yes, sir.
I've been in here since August 17th on this charge.
This is an add charge too. His original arrest was for uttering a forged instrument.
Right, this is an additional charge. It's a grand theft in the 3rd degree, all right? But you will see Judge Bailey soon, and you can address all of it with him, okay?
All right, no
All
problem.
right, you take care.
All right, too.
Andrew Turkis,
I know, but you were standing right here. You were standing right here. We could have gone right there.
delete from docket, okay. Thank you. Alexander Lamoureux,
All right.
That's North Broward, Your Honor.
all right.
The next 3 are at North Broward.
Okay, great, thank you. All right, Mr. Lamoureux, you're charged with an armed burglary of a dwelling, structure, or conveyance, and grand theft auto. I will find probable cause for the offenses. And, State, are you seeking to have him remanded?
I am, Your Honor. Your Honor, under Esaza v. State, relying upon the original affidavit. And, Your Honor, I provided both the court and defense counsel with a report from Officer Reynolds, which is referred to in the report. Your Honor, noting one, the evidence in the case, that Mr. Lamoureux was found in possession of a firearm. He acknowledged he knew about the firearm. His explanation for who owned the firearm and how he became in possession of the firearm was disproven. He alleged it was his mother's firearm. Law enforcement spoke with his mother, who advised law enforcement she does not own a firearm. While this was going on, a delayed burglary report was made from the owner of the firearm, where his car was broken into, noting specifically, Your Honor, that his car had to be broken into at some point between 11 o'clock in the evening, September 26th, and, one moment, Your Honor, approximately 3 in the morning, September 27th, making that a 4-hour time period where his vehicle could have been broken into, where his firearm was stolen from his center console. Noting, Your Honor, that the serial number also on the firearm found in Mr. Lamoureux's possession matches the serial number of the firearm that was stolen from the victim's vehicle. Your Honor, noting that Mr. Lamoureux was found in possession of a firearm at most within 4 hours of, actually, Your Honor, if I could have one moment.
Sure.
Actually, I'll cut that down. It could have, 3 o'clock would have been when he noticed it. Your Honor, Mr. Lamoureux was first seen at approximately 12:47, September 27th, at 4465 Northwest 65th Street. And it would appear based on these allegations, he was observed at all times, once located by the arresting officer. So, Your Honor, it would appear that within 2 hours of the burglary, Mr. Lamoureux was found in possession of the firearm. And as the court is aware, there is a presumption that someone that is in possession of recently stolen property as a result of a burglary committed the burglary, Your Honor.
All right, thank you, Mr. Linder. Mr. Farbarek?
Judge, the only thing that I would argue on his behalf is that he didn't go into this, based on the allegations, he didn't go into it with a firearm, that he didn't brandish it, he didn't threaten anybody. It was something that allegedly was taken during the commission of it, and while I understand that the court may find probable cause for that, I would just ask the court to not find proof evident presumption great and to set a bond in the case.
All right, thank you both. I am today, for today's purposes, sir, for bond, only going to find that the proof is evident or presumption is great to hold you without a bond on count 1 and set a $1,000 bond on count 2. You will have an opportunity to see your division judge for a bond hearing, at which time he or she may issue one. You're also going to have no contact with the alleged victims in the case. Stay 500 feet away from them at least.
And, Your Honor, lastly, to advise the court, and I didn't want to bring this up until the court made legal determinations, Mr. Lamoureux is out on release. I'm not sure if it's bond or release on 2 separate cases. One case for burglary of a structure and grand theft, and another case for burglary of a conveyance and grand theft.
All right, well, given the nature of this charge, I'm inclined to revoke those release conditions. If you could give me the case
The
number.
burglary structure is 179577 CF10A. The burglary conveyance is 175923 CF10A.
All right, so, sir, you're gonna see your division judge on those cases, and they'll decide whether or not they want to reinstate the bond. All right, good luck to you, sir. You take care of yourself.
Thank you, God bless.
God bless you. Okay. Bradley Stone. Oh, this
No
can,
problem.
this can go with that too, actually. Thank you. All right, Mr. Stone, good morning. You're charged with contributing to the delinquency or dependency of a minor and a violation of your probation or community control. I'm going to find probable cause for the offenses. Does he have any other priors? Just curious.
One moment,
Mr.
Judge.
Stone.
I'll check. I would note the VOP seems to be out of Seminole County.
Seminole, yeah, I see that.
Brad, when you get back to you, then while you're in the county.
Oh, wait a minute, I've got an NCIC sheet here.
No, go back yourself. You guys get done, go back yourself.
Okay.
It is.
All right, a lot of these are juvenile priors, so I'm not going to read them out loud, but it's pretty extensive. All right. He is not from here.
No.
All right, sir, I'm gonna set a $5,000 bond on count one, and there's no bond on count two, which is the probation violation. After you get done with your charge down here in Broward County, they will transport you up to Seminole to address the probation violation charges. Good luck to you.
Okay, can I have one question, sir?
Yes, but I would encourage you not to talk about the facts of your case.
Oh, it's not. I was just confused in the sense of when I was in booking, they told me it would be 500.
It's a $500 convenience bond based on the nature of the case and some of the priors, and you're not being from South Florida. Taking all that into consideration, I've chosen to raise the bond a bit to $5,000 on that particular charge, okay?
Yes, sir.
All right, good luck to you, sir.
Thank you.
Irvin Jackson. All right, Mr. Jackson, you're charged with a violation of your felony probation. You're going to be held without bond at this time, and you're going to see Judge Scheer on October 2nd at 8:45 a.m. All right? Good luck. Good luck to you, sir. Yeah.
No, because when they put this warrant out, I was already in custody in Dade for 2 years, so.
All right.
You understand?
I understand.
So,
I understand. But
When I finished my charge in Dade, that's when they brought me here, but I was locked up, so.
The basis for the.
I understand.
Yeah.
Talk to Judge Scheer. You'll see her on the 2nd, okay? All right. All right, good luck. Cesar Castro Fundora?
He's here present at Maine, Judge. You can find the service.
All right. All right, good morning, sir. You're charged with a violation of your felony probation. You're going to be held without bond at this time, and you'll see Judge Michael Lynch October the 3rd, 9 a.m. to address that. All right? All right, good luck to you, sir. Justin Ortiz. Mr. Ortiz, good morning. You're charged with a violation of your felony probation. You're going to be held without bond at this time, and you will see Judge Tim Bailey on October 2nd, 8:30 a.m. to address that charge, sir. Good luck to you. October the 2nd. Steve Sinecki?
North Broward Drive.
All righty.
Good morning.
All right, good morning, sir. Sir, you're charged with a violation of your felony probation. You're going to be held without bond at this time. You're going to see Judge Barbara McCarthy on October the 2nd, 8:30 a.m. to address that charge, sir. All right? All right, good luck to you.
Thank you.
Ralph Duidon?
He's here present at Maine, Judge.
All righty. All right, good morning, sir. You're charged with 2 counts of possession with intent to sell heroin. I'm going to find probable cause for the charges. Any prior record, Mr. Linder?
Yes, Your Honor. First,
It's a pleasant ring. Thank you. Okay.
Mr. Dudon is out on bond right now for possession of heroin, amphetamine, and cocaine. Charges are filed, and his bond predates this alleged offense. He has a lengthy criminal history involving dealing drugs. 2014, sale delivery of cannabis at or near a place of business. 2009, possession of cocaine with intent to sell or distribute at or near a park. Just under 37 and a half months state prison. 2009, possession of cocaine with intent to sell or deliver. He received the same prison sentence concurrently. Possession of cocaine, 2007, 18 months state prison. Possession of cocaine, 2006. Possession of cocaine with intent to sell or distribute, 2005. 2004, possession of cocaine with intent to sell or distribute, 17 months state prison. 2004, possession of cocaine, 17 months. Grand theft auto, 2005 at the BOP, 18 months state prison.
What's the case number he's on right now?
174186 CF10A.
All right. Mr. Romero?
Judge, in speaking with Mr. Diodone, he's currently working at Steak and Shake. He obtained that job approximately 3 months ago. He lives in Margate with his girlfriend. He's the sole financial provider of him and his girlfriend. At this time, I ask you not to revoke the case that he's currently out on. By holding him no bond, that's the most severe sanction this court could impose. I would ask you at this time to consider something less restrictive, such as pretrial, a level 2, so we know where he's at all times, and then he can continue to work and provide for his family. So that's what the defense would ask you to do, Judge.
All right, thank you. Sir, I am going to revoke your release conditions in case 17-4186 CF10A. You will see your division judge about that, and he or she will decide whether or not they want to reinstate conditions. In this matter, it'll be a $5,000 bond per count, sir. Good luck to you.
No, you won't.
So detectives, you have to be out 10:30, you've got a trial. Mr. Linder, if you're able, could you send Mr.
I'll call. I can't text him from here.
Okay, yeah, right, if you could call.
Maybe I should look.
It's no rush for him, so what I can do is, you think you'd be able to come back in the afternoon?
We have trial.
Trial all day, who?
Send him another message.
I'm calling right now.
Oh, okay, who were you with?
I
Do you
don't
know?
know,
You
I
don't know?
don't service a check.
Okay. Just give Mr. Jellin a call if you can.
Sure.
Let him know, and I can reset it tomorrow, because it sounds like the detectives are in trial this afternoon as well.
Your Honor, the last defendant, Mr. Dujon, what did the court set his bond?
5 and 5.
Thank you.
All right. In the meantime, Randolph Patterson.
Mr. Patterson is here present, Maine. He is approaching, Judge.
All right. Good morning, Mr. Patterson. You're charged with possession of a controlled substance without a prescription, possession of cocaine, possession of paraphernalia, and a seatbelt violation. I'm going to find probable cause for those offenses. I know Mr. Linder's on the phone right now, so let me. It's okay, Kifa. If you have the priors up.
Mr. Patterson?
Yeah.
What do you say now?
He said he's.
Thank
I'll put it on the record this time.
Georgia, battery
He's still in court?
adjudication.
He said he's finishing
sorry, I
Judge
didn't hear
Culver
the-
and he's coming right over.
2017.
2017. Okay.
Battery adjudication from the state of Georgia.
Battery adjudication, state of Georgia, 2017.
Possession of cocaine in 2005, he received a withhold.
Withhold on possession of cocaine, 2005.
Possession of marijuana in 2008. an
Possession of marijuana,
adjudication.
2008, adjudication.
2010, sale of marijuana and adjudication.
2010, sale of marijuana, adjudication.
2010 and 2014, domestic violence battery adjudication.
Domestic violence adjudication, 2010, 2014.
Correct.
Okay.
End of record.
Okay. Mr. Romero?
Judge, in speaking of Mr. Patterson, at this time, he's 30 years old. He's looking for employment. He lives with his mother in Liberty City. From what he advised me is that his mother is a school teacher. From what he advised me also, unfortunately, with all the bills and their expenses, he doesn't believe that his mother financially can afford to post this monetary bond. Judge, we'd be asking you at this time, considering what's before the court is a nonviolent offense, we'd be asking you to consider a pretrial release on Mr. Patterson's behalf.
All right. I'm not going to be able to accommodate that request today, Mr. Patterson. It's going to be a $1,000 bond on count 1, so the $2,500 bond on count 2, $100 bond on count 3, and no monetary charge for count 4. Good luck to you, sir. What did Mr. Jellin?
He said he was finishing up with Judge Culver and coming right here.
Okay, all right, great. We've got a little bit of time. Who, you know, where are you supposed to be at 10:30? Which judge? Do you know?
Don't know.
All right. Okay, all right, no problem.
It's a motion to suppress.
Oh, it's a suppress, all right. If you figure out which judge and we're running a few minutes behind, I'll just call them.
Okay, thank you.
John Vickers?
Mr. Vickers is here present, Judge of Maine.
All right. Mr. Vickers, good morning. You're charged with a violation of your parole, sir. I'm going to find probable cause, and you're going to be held without bond on that charge. The parole board will have to conduct a hearing, and they'll make a decision about what's going to happen with your parole, okay? All right. Good luck to you.
Mr. Casimir?
All right, good morning, Mr. Casimir. You're charged with 2 counts of violating your felony probation. You're going to be held without bond at this time, and you're going to see Judge Siegel on October 2nd at 8:30 a.m. To address those charges.
It was just corrected to reflect community control.
Oh, it's community control, not probation. Okay, all right. So it's 2 violations of community control, not probation. But in any respect, you'll see Judge Siegel on the 2nd. He'll decide what to do, okay?
Thank you.
All right, good luck to you. Daniel Morgan?
Your Honor,
Mr. Morgan?
Yes, Gloria.
Count 5 was corrected. It's an out-of-state case, not a Broward case.
Oh, I see. So felon, it's, they're seeking to extradite?
No, it's a 948, but it just.
We'll have
has
to
been
contact the
corrected
probation
because
it's
officer in the
it's
United
number on
It's
States.
still a 94806, it's just an out of
And
state.
then the case on the findings belongs to a different defendant because it's not a Broward County case.
But Mr. Morgan,
Is here present, Judge, at Maine?
but Mr. Morgan does have a 94806 hold?
Yes. But your findings will have a 16000325 CFTA.
Yes,
That
that's
does
not his
belong
case
to
number.
him.
Okay, I'm
If you just cross out the
gonna
CF.
cross that
in it.
out. I'm gonna cross that out, okay.
And I can, and also, Your Honor, not that I don't, you know, it's confirmed, he is being supervised.
Okay, all right, so it's definitely him that's being supervised, that's 100%.
Yeah.
It's just out of state, not a Florida. Out of state or out of county?
Out of county.
Out of county, yeah, it's a Lake County hold, I see that, okay. All right, sorry about that, sir, that's just procedural, and we're making sure that it's actually your charge that we're dealing with. So, sir, you're charged with an aggravated battery with a deadly weapon, resisting an officer without violence, driving with a suspended or revoked license, a subsequent offense, burglary of an unoccupied dwelling, and a probation or community control violation. I am going to find probable cause for the offenses. Tell me a little about his priors, please, Mr. Lee.
Your Honor, while I'm looking at, also what I would ask the court to consider is it would appear, not only based on his own admission, that he just stopped going to probation to avoid getting arrested for violating. The alleged aggravated battery was committed in an act of trying to get away from the police to avoid being arrested.
Right.
So I do have a concern about his eventual, should he be released at some point in his future appearance in court. 2000, that might be the case he's on probation for, okay. 2011 out of Broward, trafficking oxycodone. 2008 out of Broward, possession of diazepam. End of record.
Okay. All right, Mr. Romero?
Judge, Mr. Morgan's been residing in Florida his whole entire life. He's 27 years old. At this time, he is working. He works at the Outback Steakhouse. He makes approximately $9 an hour. He lives there with his girlfriend and his children. They've been residing in the same apartment in Margate for the past 6 months. Judge, considering he has a no bond hold, so it's not like he's going to be released or be out of custody. He'll be still in custody as far as under the supervision, as far, I believe, in Lake County. We'd be asking you to set a reasonable bond as to counts 1 and 4, Judge.
All right, sir, I'm going to set a $7,500 bond on count 1. There's no monetary charge on counts 2 and 3. It'll be a $5,000 bond on count 4. And there's no bond on count 5, which is a probation violation. When your cases are done here in Broward County, they will transport you to Lake County to answer for the probation violation, the alleged probation violation. Good luck to you, sir. Mark Alamo. Mark Alamo?
I'm gonna reach out to him.
Was that the lead officer?
I believe confinement status has information on that, Judge.
Deleted from the docket, okay, I had a feeling. Patrick Dorsenaire?
Mr. Dorsenaire, come on up, please.
All right, good morning, sir.
Morning.
Good morning. Sir, you're charged with 2 counts of abuse of a child without great bodily harm. I'm going to find probable cause for the offenses. Mr. Linder, any priors?
I'm not showing anything. Does pretrial have anything?
Your Honor, I show no record.
All right, Mr. Romero?
Judge, I didn't hear what pretrial
We
said.
have
No record.
Okay, yeah, that's exactly what Mr. Dorsenaire said. Judge, from what he advised me, he's been residing in South Florida his whole life. He is 33 years old. He is employed. He works for Stan Ron Still. It's a warehouse. He's been working there for about 2 years, making approximately $13 an hour. He did just attain a second job. He works at Wawa's gas station, and he just started that employment. As the state confirmed, this is his first arrest ever. He is a registered voter here in Broward County. He did graduate from Deerfield Beach High School class of 2003. Judge, considering his lack of any sort of criminal history, his strong ties to the community, I'd be asking you to take that into consideration and impose a reasonable bond on Mr. Dorson Reeves' behalf.
All right, sir, I'll set a $1,000 bond on count one. I'll release you on your recognizance on count two. And you're gonna have to have supervised contact only with the minor children. That order will be subject to change by the dependency court. Otherwise, for now, you can't have any unsupervised contact with the two minors. Do you understand?
Yes, sir.
All right, good luck to you, sir. Billy McGill?
North Broward, Your Honor.
All righty. All right, good morning, Mr. McGill. You're charged with a petty theft in the second degree. It's a third subsequent offense, so that is a felony charge. The bond on that, I'm going to find probable cause, and the bond will be $750, sir. Good luck to you. Brian Ahern?
Are you both?
All right.
regards to Mr. Ahern's case.
Sure.
And probable cause, I know that there's a charge or a count of resisting arrest without violence. I didn't see anything in the probable cause that would indicate that.
Did you have the second PC? Says he fled. There's, the second PC has more about the Grand Theft Auto. It's
The handwritten PC.
I do not have that.
Here, let me give you.
Yeah, I'll show you.
Yep.
I see it now, Judge.
Okay, all right.
Thank you.
But it's a good point. All right, sir, I'm going to find probable cause for the offenses of petty theft in the second degree, a third subsequent offense, a felony offense, grand theft auto, and resisting an officer without violence. You also, sir, on counts 2 and 5, are charged with violation of your probation or community control. So I'm going to find probable cause for all counts. Sir, I'll keep the standard bonds in place, $750 on count 1, $1,000 in count 3. There's no bond for the probation violations. You'll see your division judge on October the 2nd, 9:45 a.m. to address the violation of probation charges. The resisting is a no monetary charge bond. All right, good luck to you, sir. You take care. Anthony Cotrasio?
He's here, President Judge at Maine. He declined the service of public defender.
All right, good morning, sir. You're charged with petty theft in the second degree and violating your probation or community control. I'm going to find probable cause for the offenses. Bond on count 1 will be $25. There's no monetary bond. I'm sorry, there's no bond on count 2. The probation violation, you'll be held no bond. And you'll see your division judge on October the 13th at 8:30 a.m. Do you have a private attorney in that case?
Yes, I do. Yes,
All right.
I do. Is there any way I can get an earlier court date? My father's 87 and 100% disabled. I'm a legal guardian. He's legally blind and deaf.
That's what I was.
Any way I can get an earlier court date?
Well, that's what I was going to suggest to you. Who's your attorney? What, you know his name or her name?
Yes, Richard Delafera.
Richard.
Oh, I'm sorry, Your Honor.
Richard Delafera.
I'm sorry, Mr. Delafero. I apologize. He was here this morning. He's familiar with the allegations. He's going to be contacting Judge Fine's judicial assistant to try to get an earlier court date.
That was going to be my suggestion. All right, and I know Mr. Delafera.
Yeah,
I'm sure he's on top of it. Yeah, he's going.
Yeah, we actually pulled up Judge Fine's docket next week on Odyssey.
All
to
right,
see
good.
if
I know Judge Fine pretty well too. I think he'll do it.
He's gonna try to see if he can get one for Monday morning.
All right, good. All right, did you hear that? They're trying to get you for Monday morning. Okay. All right.
Okay.
All right. Good luck to you, sir.
Thank you, sir.
All right, you take care. John Proby.
And Judge, with regards to Mr. Proby's case, I didn't find probable cause for there was no confirmation of the drug. It just says that they found 2 pills in his pocket.
No testing.
I agree.
Okay. All right, so I'm going to find no probable cause for count 2, which is possession of alprazolam, and release Mr. Proby on his own recognizance on that charge. I am going to find probable cause, however, for the grand theft charge. Does he have any other priors, Mr. Proby?
I don't see anything, at least not as an adult.
As far as you know, Mr. Proby, let me ask it like this. As far as you know, do you have any reason to go back to Burlington Coat Factory?
Judge, at this time, Mr. Proby's not gonna be going back to Burlington Coat Factory.
Okay, got it. All right, I'll release you on your recognizance on count 1 as well. Don't go back to Burlington Coat Factory, okay? All right, good luck to you. You take care. Kevin Dennis.
And I also have a probable cause objection to Mr. Dennis.
Okay.
With regards to the criminal mischief charge, there's nothing indicating what was damaged, the amount of damage that was caused. There's just nothing that indicates anything about it.
Couple more, 3 or 4 more. They're like second
Okay,
to the last.
all right, Mr. Linder?
That's, I can't refute that.
All right. So, sir, I'm going to release you on your recognizance on the charge of criminal mischief, over $1,000. I'll find no probable cause for that. You are charged with resisting an officer with violence and resisting an officer without violence. I will find probable cause for those charges. Does Mr. Dennis have any priors?
I'm not showing any priors as an adult. It looks like there are juvenile priors, though.
It's not first offense.
That's what we have as well, juvenile.
All right. Anything you need me to go off the record to hear?
Looks like his most recent was somewhat similar to count 2.
I understand. All right.
It does appear, Your Honor, after speaking with him, that he has no he has no stable residence.
Okay.
I just sent the.
All right. Mr. Farber?
Judge, if I could just inquire from him.
Sure.
Mr. Dennis, Mr. Dennis, do you have anywhere to go if the judge were to release you today?
Yes, I go to my mom's house.
And where does she live at?
3011 Northwest 17th Street, Fort Lauderdale, Florida.
Okay, and do you have any money in the bank?
No, I do not.
Is there any amount of bond that you would be able to afford today?
Yeah, 200-300.
Okay, and who would post that for you since you have no money? Who would post that bond for you?
I would have to call my mother and tell her how much the bond is, and she would post it for me.
Okay, and she would be willing to do that for you?
Yes.
And do you currently work?
No, I do not, sir.
And how long have you lived here in South Florida?
I stayed here all my life.
Okay, Judge, I have nothing further.
All right.
Excuse me.
Yes,
Is
sir.
there anybody I can explain the case to?
Yes, your public defender is the one that you would have the opportunity to explain the case to. You should not talk about the facts of your case at today's hearing. You will have the option to either hire a private attorney or the public defender's office can represent you at a very low cost. They're representing you today for free at today's hearing, okay?
All right.
All right. So it's,
I'm sorry.
Yes.
It's not that he has no verifiable address. We attempted to get a hold of his mother, and we were unable to do so. So if the court is inclined to do pending verification, that's fine. It does appear, based on what the defendant has told us, that he may have stable residence. We just not have been able to verify it.
all right, that changes things. So I'll do a $5,000 bond on count 2, a $100 bond on count 3. I'll place you pending verification of pretrial release. So in other words, if pretrial release contacts your mom and she says, yes, Kevin is going to live with me, then you'll be released to the custody of pretrial. You're going to have to register with them and follow any conditions that they require. Do you understand?
Yes, but y'all got no way I can help y'all contact her?
Sometimes we'll send people to the home yard. We'll take care of it, Mr. Dennis.
Right.
We're working on it.
They have their ways.
What was the bond again? I'm sorry.
5,000,
5,000 on count 1?
count 2.
And the other thing that I would just tell you is that if you can contact your mom, you can let her know to contact pretrial as well, so that she can call them during business hours, okay?
And we left her a voice message.
I'll
We
give him a few
already
minutes. He
left
said
her a
between
voice
5 and 10
message,
minutes,
so
so I'm giving him a few minutes. I'm giving him a
Okay.
few minutes.
Thank you.
How can she contact pretrial?
We left her a voicemail, sir.
What number?
The number you gave us, sir.
Which one? I gave you 2.
Well, whichever one you gave her is what I wasn't the one that did it, but the interviewer you spoke with, you gave her some numbers. She just told me she called and left a voice message.
Can I give me the number? I can give it to them?
Go ahead,
Do the
give it
attorneys
to
have
me
phone
again.
numbers in their courtrooms? I
Go
need to
ahead.
contact the attorneys and Judge Solomon.
Don't write it down as you say it.
Go ahead.
I need to talk to the
Say
attorneys and
it.
Judge Solomon. I emailed them.
554-205-1497.
Is that a cell phone or a landline?
That's a cell phone. His name is Michael.
And who is Michael to you?
He's a cousin of mine.
Okay, does Michael have a last name that you know?
Grace.
Thank you. We'll call Mr. Grace.
Judge,
Yes.
are you able to reach out to Judge
Thank
Solomon?
you.
Judge, it's who?
Solomon?
Oh, it's just Solomon?
The detectives have
Solomon
motion.
or
Yeah.
what you said?
That's where
No
Bill's
problem.
from. Their cases are.
One second, let me send her a
Never mind,
text.
thank you. Mine are here.
That number goes straight to voicemail.
Straight to voicemail?
I'm leaving it myself. I don't know, you know, just, they like to do that, because they don't want us to tell somebody else. You don't get my mama. I'm sorry, you don't want me to tell.
Deputy at North Broward?
This is the Broward Sheriff's Office.
You can let him know that they're leaving a message for his cousin now.
Michael Grace.
Alright.
Great, thank you.
Venus is currently in custody, charged with criminal mischief, resisting with violence, and resisting without violence.
Do you know the name of the defendant in that case, detectives?
Yes.
It's defendant
Good?
10:30 more.
Okay. Should get back to me quick.
Thank you.
Oh, no problem at all. Jason Mace, or Mayes?
Mr. Mace is here, present, Judge Amin.
Oh, good, there's Mr. Jalen. Mr. Mace, I'm actually gonna recall your case. I've gotta just call one case real quick. All right.
What's that? What paper?
And don't worry, if we go over, she knows I've got you, and if she doesn't respond on text, if she's not looking at her phone, I can always call over there. All right. All right, Mr. Jelen, are you ready for,
Yes, Jordan.
all
Bill.
right, great. Jordan Litter? I'm sorry, Little?
Everyone's been very patient, Bill. Don't.
She said no problem, guys.
Yeah, right? I think that's all right.
All right. All right. Mr. Little, good morning. Sir, you're charged with 8 counts of possession of a weapon or ammunition by a Florida convicted felon, 1 count trafficking in oxycodone between 7 and 14 grams, thank you. Possession with intent to sell, manufacture, or deliver Xanax or alprazolam, and possession of drug paraphernalia. Your attorney, Mr. Jelen, is here on your behalf, and we also have 2 Hollywood detectives here who I believe wish to testify.
Your Honor, I don't have any.
Oh, they don't even need to testify? Oh.
I got some questions as long as they're here. You may want to keep them, Judge.
Well, it's a non-adversarial hearing, there really
Well,
is no...
I think they got some issues with this driver's license under the gun conveniently. I mean, I don't know why it wasn't scotch taped to the gun, but,
All right. Any arguments as to probable cause, as you said, Mr. Jelen?
Okay, so let's break it on down. We got a 2, 4, 6, 8-page probable cause affidavit. So the pills, it says something about poison control. Do we have any lab results that these are narcotics? That's the first argument, Judge.
What, I'm so sorry, what page are
It
we
doesn't,
on?
I read it quickly, but I didn't see anything about Valtox or any kind of testing on the drugs. It says something about poison control.
Let's see if I can find that notation.
Yeah, it says poison control, advised they were Percocets, but I didn't see any testing.
Okay, so they confirmed it with poison control, okay.
But what do they confirm with poison control, Judge? That doesn't say that the drugs were tested.
Okay,
So there's no probable cause on the drugs.
okay.
Next, if I'm reading all this correctly, weapon. So I'm guessing each charge is for a bullet or something?
Yes.
Okay. Actually, and hold on, back to the drugs. Where does the alprazolam come on? Again, I read it quickly. They're alleging a sale was the Xanax supposedly in the room later? Oh, wait, I'm sorry, here, yeah, so, okay, the Xanax is supposedly in the open, yeah, in the room. So if I'm reading this correctly, Mr. Little's not present when this home is searched. So the transaction allegedly happens in front of his residence, and then, okay, so then the next question, okay, so it's consent to search. So where is the consent to search form, Judge?
Okay.
So I don't, it looks like an illegal search pending, again, if there's a valid consent to search form executed, that's an argument whether it was coerced or not later, but we don't see the consent to search form. And then it builds on the credibility argument, which is there's no statements or anything tying to this except for some alleged people living there. And then if you read on, it's common sense, they find a gun in a room with his identification card under it. A gun in his room. Let me read the exact language. Okay, directly under the handgun was Little's Florida identification card. I cry foul. So, Judge, based on the credibility, I don't understand, I don't know how they get into this house. This looks like something's funny has gone on here. And then there's no drug testing for the drugs, so you have to find no probable cause on this whole thing, Judge.
And, Your Honor, I'll respond to each of Mr. Jellen's arguments one by one. First off, at a minimum for probable cause for pills, field testing is not required. Actually, I don't believe it's required even at trial. Pills can be, excuse me, excuse me, you don't mind, right?
No, I don't
All
mind.
right. Pills can be identified by markings on them, which is why the FDA requires markings to be put on pills, so that if someone is illegally in possession or if someone overdoses and pills are found, it can be determined what those pills are. That is why law enforcement contacted poison control to have the pills identified. Two, Mr. Jones' argument, I believe it was regarding the consent matter. Well, one, it specifically states that the owner of the property who leases the property to Mr. Little gave consent, so that is appropriate. Two, Mr. Jones' argument that because the consent form is not provided, that the court shouldn't find probable cause. That just isn't, there's nothing in the law or case law that I'm aware of, unless Mr. Jelen has some, that supports that. That would be akin to arguing in a murder case if a weapon's required, that law enforcement has to provide the gun in court to have probable cause found. It's a sworn affidavit. My understanding is the courts have found, as long as it's a sworn affidavit, that is acceptable for, if the allegations would support probable cause contained therein, that is acceptable for first appearance. And lastly, as far as where the firearm was found, luckily, Mr. Jellen's belief that something didn't happen isn't the basis for a court to decide whether probable cause exists or not. All that is required is if it is alleged, if it's sworn to, and the court finds that that would satisfy probable cause, that is the standard.
But also, there's credibility for the court to determine as well. We know that. I mean, come on, Judge. What else, what's tying him to this gun or this money or the drugs in the room? Supposedly his ID is under. I mean, come on, Judge. There's no other belongings, no other mail, no other clothes, no other nothing denoted in here. And again, I need to look at the case law. Mr. Linder makes his point on the, on this, but you do this more than I do. How often do you see where they don't even valid tax the drugs, or at least, doesn't even mention the name of the poison control officer? I mean,
Actually, I can answer that. Pills, every time. Every time it's identified through poison, through poison control. Two, they have the poison control, operator's number, which is another form of identification, Your Honor. Secondly, maybe Mr. Gentleman missed this part, but as far as what was found in the room, I'll go through it. Let's see. They found, in addition to his identification card, yellow carbon copy paper, which states State of Florida versus Jordan Little.
what, Eric, what paragraph, sorry?
It's a paragraph starting with Detective Cincher, who's still at the incident location. It's
Got it,
page-
got it.
Going to the next page. One moment. I believe they found. Medical paperwork with his name on it. One moment, Your Honor.
Where's that?
One moment.
Yellow carbon paper, which is a court paper, right? I don't see the medical paper, Eric, where's that?
Additionally, Your Honor, I would note they had testimony from the property owners that Mr. Little had moved in on that day's date.
All right, thank you both. Everyone has done a very, very admirable job and argued very well on the facts and on the law. So I am going to find probable cause for all offenses. On count one, I'm going to issue a $5,000 bond. I will release you on your recognizance on counts 2 through 8. Count 9 will be a $75,000 bond. Count 10, $1,000 bond. And count 11 is a $100 bond. Is this defendant being supervised by pretrial release?
Yes, he is. The defendant is currently being supervised in case 15-13331, CF10A, robbery with a firearm or deadly weapon, was placed on pretrial supervision with a GPS, electronic monitoring level 1 on January 4th. Based on this court's finding of probable cause, we're going to ask that his pretrial status be revoked at this time.
And Judge, I'd like to be heard on that, please.
Please, Mr. Jones.
So that other case, the other case, the alleged victim on that has, I took it over in the middle. There's been all kinds of problems getting him in for deposition. I can't speak for before I came on it, but it must have been I'm thinking a few times. And then the time I was there, he didn't show up. And then he was set during the hurricane, so it had to be reset. So that's coming up in October, because there's co-defendants. So that case, I'm thinking, is going away. I can't guarantee that, obviously. But the issue is he's had no problems on pretrial up until this allegation. He has what appears to be an uncooperative witness on that, which speaks volumes, obviously. Lastly, you did set high bonds. So, I'm not arguing about that right now, but if he's able to post that bond, certainly in conjunction with being on pretrial, which he's had no problems up until these allegations, he's gonna be able to assured, obviously with a $75,000 bond, that he's gonna make it to court if this stuff is even filed.
Well,
So I'm hoping you can keep him, what? Hello?
no, please finish. Please finish.
I'm hoping you can keep him still out on pretrial. Again, with that high bond, you're assured he'll be back and there won't be any further problems, in conjunction with the fact that it appears he's got an uncooperative witness on the other case.
Your Honor, just to let the court know also, he, based on the order I have here, the defendant was to post a $50,000 bond and then be placed on a level 1 lockdown, as the court is aware.
And that bond was placed, the $50,000 bond?
Yeah, he did, he posted bonding on pretrial.
So, Your Honor, and I don't know for what the court has to consider today, that whether a witness or victim has shown up for deposition yet or not is really that relevant. The concern is, he's out on a first-degree felony punishable by life, violent offense. He's given a $50,000 bond, pretrial release with a GPS monitor.
Level 1.
Level 1. Not even supposed to leave the house. And here we are today on a first-degree felony that has a minimum mandatory prison sentence, an allegation that he's in his possession a firearm which I imagine is probably a condition of his release that he's not supposed to be in possession of any firearms or weapons, which is even more concerning considering the allegations from his pending case involves a firearm.
All right. It's not an easy call, sir, I have to tell you, and your attorney makes a compelling argument, but for today, I'm going to revoke your pretrial release conditions, and you'll go back and see your division judge. Mr. Jellin will set up a date for you, I'm sure, very soon, and he or she will decide whether or not to reinstate those conditions, all right? But well done by everyone, and please be in contact with your attorney as soon as you can, sir.
Jordan, you got my phone number? Huh?
No, I don't.
You want to write it down?
Yeah, yes. Hold on. Okay, what is it?
954 605 6413. 954 605 6413. All right? Thank you. Thank you, Hector.
All right, thank you. Good to see you, Mr. Jellin. Thanks, see you later. Take care. Good luck to you, sir. God bless.
You can read my writing, right? 954 605. Perfect. Very good.
I wasn't that far.
Jason Mayes, or Mayes.
Mr. Mays, is here present, Judge O'Main?
All right. Good morning, sir. You're charged with battery on an officer, resisting an officer without violence, and resisting an officer with violence. I'm going to find probable cause for those offenses. Does Mr. Mayes have priors, Mr. Linder?
One moment, Your Honor. Your Honor, I'm showing 2012, 2 counts of possession of cocaine with a violation of probation, 2010 theft, 2007 uttering a forged instrument, unlawful use of false name ID with the VOP. End of record, Judge.
All right. Mr. Romero?
Judge, in speaking of Mr. Mays, he's been residing in South Florida for 17 years. He is 31 years old. He's employed. He works at a company called Yerby Stucco and Landscaping. He's been employed for that company now for about 2 years. He makes approximately $60 per day. He lives in Miramar. He lives in a duplex with his mother. His mother is 60 years old and she's on disability. They've been residing at the same location for about 8 years. Mr. Mays is the person that, like, his mother's caretaker, who helps her with all the chores, helps her, reminding her as far as her medication, taking her to and from her medical appointments, everything like that. So his mother relies on him as far as every type of support that she needs. Judge, in listening to the prosecutor, Mr. Linder, I believe his last exposure to the criminal justice system was roughly about 5 years ago. We'd be asking you at this time, and speaking to Mr. Mace, he doesn't think his mother could afford any sort of monetary bond. If pretrial can verify his address, Mr. Mace would ask you to consider releasing him on pretrial release at this time.
Your Honor, we could not verify his address at this time.
All right, let's. All right, let's make it 1,000 on count 1, release him on count 2, $500 count 3. We'll do pending verification to pretrial release, okay? So as soon as pretrial release can confirm that you're going to be living with your mother, you can be released to their custody, okay?
And Judge, would you sign a photo order as well?
Yes, I'll sign that order. All right, good luck to you, sir. Rudolph Price. All right, good morning, Mr. Price. You're charged with a petty theft in the first degree and a violation.
Mr. Price declined the services opposed.
Oh, thank you, Mr. Romero. So, sir, you're charged with a petty theft in the first degree and a violation of your parole. I'm going to find probable cause for the offense. Count 1 will be a $100 bond. There's no bond on count 2, and the parole board will conduct a hearing about the outcome of your parole. All right? Good luck to you, sir. Lorenza Wright.
Mr. Wright, come on up.
All right, good morning, Mr. Wright. You are charged with grand theft auto, resisting an officer without violence, a violation of your probation or community control, that's 2 counts, burglary of an unoccupied conveyance, and petty theft in the second degree. I'm going to find probable cause for the offenses, sir. Bond on count 1 will be $1,000. It'll be a $3,500 bond on count 4. There's no monetary charge on counts 2 and 5, no bond on the probation violations, and they will set up a date for you, sir, to see the division judge to address those. All right? Good luck to you. Yes, L'Oreal. Yes.
He has to have a hearing scheduled and the case number, because the case number was not plugged in. So he does not have a court date at this time.
Oh, I see, right, there's no court date yet. I did. I did.
Oh, I gotta get a new dental plan.
All right, you'll talk to the clerk's office and
gotta get a
they'll,
new
all
dental
right,
plan.
all right, so we'll make sure that it
I gotta
gets
get a new
set.
dental plan.
All right, Dane Scheisler or Schisler?
He's here, President Judge Jermaine.
All right, good morning, sir. You're charged with resisting an officer without violence, a violation of your probation or community control, reckless driving, failure to register a motor vehicle, and operating a motor vehicle without a license. I'm going to find probable cause for those offenses. The bond on count 1 will be $100. There's no bond on count 2, which is the probation violation, and no charge on counts 3, 4, or 5. You will see your division judge soon. Again, there's no court date set for him on this yet, but they will set it up for you. All right? Good luck to you, sir. Maurice Lewis.
No trial, Judge.
All righty.
No trial, Judge Davis.
Oh, hey, Deputy McCoy, how you doing? Nice
I'm great. How about
nice
yourself?
to see you, sir. Everyone's well? You okay?
All is well. How about
Good,
yourself?
good. Doing good. It's very nice to see your face, sir.
Yes, it is.
All right. All right, Maurice Lewis, sir, you're charged with 2 counts of violating your probation or community control. You're going to be held without bond on those charges at this time, and you will see your division judge on October the 3rd, 8:30 a.m., to address those charges.
This one question, what are
Yes.
the 2 counts?
Let's see, count 1 is sale of marijuana, and count 2 is possession of a controlled substance.
Those shouldn't be on my record at all.
Okay.
Those aren't my charges. When I was coming in, the police officers told me my only charges are violation of probation for 1 count. They never told me it was for any of that. This is the first I'm hearing of that, to be honest. Even when I was in jail, I was even read my Miranda rights. I wasn't heard nothing about this.
Okay. Well, who's this judge? Is Division FF?
Cholera, I think.
Judge Cholera? Okay.
Yeah.
You're going to see him very soon. I promise you, he will look into it. And do you have a public defender representing you? Have you, who represented you in the case?
It was my public defender, Kim Siegel.
Good, okay, good. So, do they usually reassign the same PD? Will she stay on board?
Yeah,
She's in the same quorum, okay. All right, so your public defender is gonna look into it. I promise you, they do a really good job. And if one of those charges is not supposed to be there, they will make sure to let Judge Colera know, okay?
Yeah, I don't think either of those were supposed to be there. So if you could contact my public defender, that would be the most amazing thing in the world. I appreciate it.
I'm not gonna do that, but Mr. Farbaric is here.
Right, what happens is somebody will probably come out to see you in the next day or two to get you signed up for a public defender. Once the application goes through, they'll open the file up. If we're appointed, somebody will come out to see you, or you may actually beat them to court because they do set these things fairly quick.
Okay, so I'll see Judge Clara on October 3rd.
October 3rd, exactly. So not too long, okay? All right, good luck to you, sir. You take care of yourself.
Thank you.
Thank you. They don't keep you assigned, if there's probation, they don't keep the PD's office assigned, you get off the case and then they reassign?
Yeah, they have to
If they're sort of re-up. I see, that's interesting, I never knew that.
I know I don't have one.
All right, Frederick Pinkney?
So I'm getting
Mr. Pinckney is here,
64
President
cents
Judge
increase on
Jermaine.
my vision insurance.
All right. Mr. Pinkney, good morning. You're charged with resisting an officer without violence, driving with a suspended license as an habitual offender, and aggravated fleeing with injury or damage. I'm going to find probable cause for those offenses, sir. Does Mr. Pinkney have any priors?
Yes, Your Honor. His history includes keeping you in suspense, Mike. DWLS 2014, possession of firearm or ammunition by convicted felon, 08, possession of cocaine, 08, 2001, burglary of a dwelling, aggravated fleeing and eluding at a high rate of speed, grand theft auto, violation of probation, 59.5 months state prison.
All right, thank you. Mr. Romero?
Judge, in speaking with Mr. Pinckney, he's been residing in South Florida his whole life. He's 34 years old. He lives in an apartment with his wife and 3 children, ages 1, 3, and 4. At this time, he's the sole financial provider of his family. He works in construction, getting paid approximately $10.50 an hour. His wife is currently pregnant, so she relies on him for all her and her family's financial support. Judge, from what he advised me, is he does not believe his wife has the financial ability to post his bond. And what the state said, I believe his last contact with the system was 2014, and prior to that was 2008. We'd be asking you to consider releasing Mr. Pinckney on pretrial release.
And Your Honor, even without his priors, just based on the nature of count 3, the state would object to straight pretrial release.
Yeah,
That would be up to the court. We don't make recommendations on charges such as these.
right. The damage was to his vehicle.
Yeah, and I'm not even so much concerned about the damage. It's just, one, just the nature of the allegations. 2, I mean, these kind of things, this is what puts people in jeopardy.
So, sir, I'd be inclined to release you to pretrial. The conditions would be, though, fairly strict. You couldn't drive or operate any kind of a motor vehicle or conveyance, so mopeds, motorcycles, things like that. You're going to be on a level 2, which is you're going to have to wear a GPS monitor. You can go to work, you can go to school, you can go to church, and that's pretty much it. So otherwise, you're going to be at home.
No bond necessary?
Now, let's see if that's if he wants to do it.
Judge, in the alternative, Mr. Pinckney is asking, what type of monetary bond are you considering setting on count 3 without the level 2 pretrial?
All right. We could do a $5,000 bond on count 3, $750 count 2, and $100 in count 1. And you cannot operate a motor vehicle or conveyance of any type.
Thank you, Judge.
All right, good luck to you.
So, I don't know, what's being done?
Bond. Okay, good luck, sir. David Bolterman? Oh, okay. All right, I'll find probable cause. All right, then that is it for the morning. Good job, everyone. Very big docket. I'll see you at 1:30.
I'll see you.
Great.
Sounds good.
Thank you.